Min Kim. I'm an attorney and partner at the Edison, office, as well as, two contributors here employed as paralegals. You have Nina and Hugo. We're going to be talking about PERM. I suppose, the three of us, we thought that it was probably best to try to approach this huge talking point as some people who've practice in this area know. When you talk about PERM, you can make a seminar an entire day's length about all the different issues. Some that are kind of firm and decided by the Labor Department, others that are a little bit more subject to interpretation, and we can pretty much talk on and on about the PERM labor certification process and how that impacts our employer and our employee clients. But we'll spare you that. We'll spare you, talking about this too much. But we did think that there's some value in talking about it from both standpoints. Maybe someone who is fairly new to the PERM process, kind of like an intro, basic rundown of some of the things to keep in mind as you handle your first PERM cases, as well as some other practitioners and caseworkers who might be a little bit more experienced on PERM labor certification, perhaps maybe carving out some time towards the end to talk about some advanced issues, as well as some some hypos to kind of get your brain juices going. So with that started, I'm going to hand it off to Hugo, who's going to start us off with talking about the prevailing wage determination, the importance of that, as well as an intro, overview of what the PERM process is all about.
Thank you so much, Min. Good morning, everyone, and thank you for attending today's True University. Today, we'll be talking a little bit about the PERM process and what it entails. We will briefly take you through the complicated process and hopefully answer any questions that you may have. So with that, let's get started. So first and foremost, in order to understand the PERM process, first we have to ask, what is a PERM? PERM stands for Program Electronic Review Management System, and it is ultimately a permanent labor certification that allows for an employer to hire a foreign labor worker to work permanently in the United States. However, before the U.S. employer can submit an immigrant petition to the Department of Homeland Security's U.S. Citizenship and Immigration Services, in other words, USCIS, the employer must first obtain a certified labor certification application from the DOL's Employment and Training Administration, ETA. The DOL must certify that to the USCIS that there are not sufficient U.S. workers able, willing, qualified, and available to accept the job opportunity in the area of intended employment, and that the employment of the foreign worker will not adversely affect the wages and working conditions of similarly employed U.S. workers. Now, there's a couple of qualifying criteria, as you can see here. So there's the first criteria: applications filed on or after March 28, 2005 must comply with the new PERM process and adhere to the new PERM regulations. The second qualifying criteria is that there must be a bona fide full-time permanent job opening available to U.S. workers. Because remember, you have to show that there's not enough U.S. workers available, willing, qualified, and able to accept the job opportunity. The third qualifying criteria is that job requirements must adhere to what is customarily required for the occupation in the U.S. and may not be tailored to the foreign workers' qualifications. So it can be anything, out of the ordinary. It can be anything out of the box, too wild. It has to be within what the occupation states, on the BLS and OES and things like that. The final criteria is that the employer must pay at least the prevailing wage for the occupation in the area of intended employment. So they have to pay at least the prevailing wage or higher for them to qualify. Now, in order to file the PERM, there's three major steps. The first is the prevailing wage determination, which I'll speak briefly about. The second one is the pre-filing recruitment steps, advertisements and things like that. And the final step is filing the actual PERM application, the ETA Form 9089. So what is a prevailing wage determination? Prior to filing the Form 9089, which is the actual PERM application, the employer must request and obtain a prevailing wage determination from the National Prevailing Wage Center. The employer is required to include on the ETA 9089 and NPWC provided information. They have to include the prevailing wage tracking number, the SOC code, occupation title, skills level, wage source, determination date, and expiration date. So all the information that is provided when the prevailing wage is determined will have to be included on the PERM application ETA 9089. Now, how do you file a prevailing wage determination? Prior to 2019, we actually used a system called iCert. So when I first started here, that's what I was using, and gradually they actually, and gradually they actually began switching us over to the flag system. So currently, in order to file a prevailing wage determination, you have to file it through the flag system. So this is just a sample of what a prevailing wage determination looks like. They're fairly relatively simple. The first page is really just employer or petitioner information, as well as attorney information if the attorney is the one submitting the prevailing wage determination once it's determined. Now, there's a couple of categories to keep in mind, just to go a little bit more in depth with regards to the education and experience qualifications that you may be putting on your prevailing wage determinations. There's ultimately two main categories when filing prevailing wage determination, employment-based 2 and employment-based 3. Which are both listed here. So you may qualify under employment-based 2 if you're a member of the professions holding an advanced degree or its equivalent, or a foreign national who has exceptional ability. And as you can see, there's multiple ways to sort of equate that. Similarly, you may qualify or you may be eligible for EB3 if you're a skilled worker, professional, or other worker. And again, if you look at, sort of the bullet points we have here, there's different ways that you can sort of qualify under each criteria. For example, to qualify under EB2, typically it's required a bachelor's with 5 years experience qualifies under EB2, but similarly, so does, a master's with 0 years experience or a master's with 2 years experience. So there's different ways to qualify under either criteria. You just sort of have to look at the qualifications that the beneficiary has. Now, why is it important? Why do we have to keep in mind whether we're filing under EB2, employment-based 2, EB3? Why is that important? The reason being, if we go to the next slide, you can see that there's actually future implications, to filing under either EB2 or EB3. The implications are, as you see here, once we get to the adjustment of status phase, to apply for your green card, whether you filed under employment-based 2 or employment-based 3 is going to determine when you can actually adjust your status. For the most part, if you see, a lot of them have a C, which is current. So for the most part, a lot of them can file under employment-based 2 or 3 at any given time. However, if you see some of the dates, for example, under the Indian national chart, so already right there, you can see there's a couple months difference when, when it comes time to adjust your status. So those months, mean a big deal when you're waiting years and years to get your green card. So those months are fairly important. Similarly, if we go to the next page, this chart is for when you can actually file your petitions, to sort of wait in line to get that visa number. So there's future implications, with that. Now we move on to the pre-filing requirements, which is the recruitment phase. One of the requirements for the petitioning company seeking PERM certification is to post PERM advertising in various media channels. There is a couple of media channels that are required for posting, and there's a couple that are optional, but they're still, you still have to select a number of them to run in. So the list that I have here is a list of the required advertisements that need to run once the prevailing wage determination is determined. So the first one is a job order with the state's workforce agency, which is the SWA, and that must run for 30 consecutive calendar days. Every state has a different sort of policy and regulation when it comes to their SWAs and their ads that run on their specific state agency work sites. Similarly, another ad that we have to run is the 2 Sunday ads. They must run 2 weeks consecutively, and they also must run in the newspaper of general circulation in the area of intended employment. So you can't just run it in any local newspaper, any small newspaper, to avoid paying a higher cost. You have to make sure that it's the newspaper in general circulation of the area of intended employment. Finally, the last required advertisement that we must post is the notice of filing, the 10-day posting, which is actually placed at the place of business. And it's supposed to include the job title, of course, the job duties, requirements. And this is supposed to be posted at the place of employment or at the place of business for 10 business days, consecutive business days. So those are the 3 mandatory ads that must run after the prevailing wage is determined. And if we move on to the next slide, we have a couple that are optional, but they're still mandatory. So of this list, you also have to post 3 additional ads aside from the required ads. So typically what we like to do, we like to just make it easier for the employer. So we'll typically run the company website, employment referral program, and a third job search website. It's just the easiest because since they're already posting the 10-day posting, they can just post the ERP, the employment referral program, right next to it. The company website is fairly easy to add career opportunities. And finally, the job search websites, we typically ask for a 7-day online monster ad, Indeed ad or something like that when we request for the Sunday ads, the 2 newspaper ads. So just to simplify it for our employers, but typically these are the ads that have to run, the 6 ads, and you have to run them, of course, some for 10 business days, some for 30. But once the ads are completed, you have to wait for a grace period of 30 days, just in case there's any applicants or anything like that. We have to give them time to submit, the resumes and applications and things like that. So once the ads are run, you have to give them a 30-day grace period. And at that point, you can ultimately file your PERM. But at this point, I'd like to hand it off to Min, who will go a little bit more in depth regarding the regulations for recruitment and the different intricacies. Min?
Great. Thank you, Hugo, for starting us off and providing that excellent overview regarding PERM. Before I kind of jump into PERM advertising content and some of the high level points that that the folks that the audience here should kind of keep in mind. Just a couple of clarifying points I do want to touch upon, regarding that overview that Hugo provided. I suppose a common question that I receive in representing both the employer and the employee through the PERM labor certification process is that the fact that an employee might have an advanced degree, a U.S. master's, and let's say so many years of experience, should that control in determining what preference category the employer decides in pursuing this permanent residency application for the foreign national worker, EB2 or EB3. And as Hugo explained, of course, the qualifications of the foreign national employee are relevant, but I suppose the story should not end there, because a more controlling point is what the employer minimally requires. So it's I suppose the example that I often give is that it's great that an H-1B employee has a PhD degree and 20 years of experience, but if the job that they hold at a minimum requires a bachelor's degree and 4 years of experience, then it's a bachelor's degree and 4 years of experience, and therefore we're going to file the EB3, and that's the preference category that we go for. It's unquestionable that the foreign national is qualified for the role based upon his PhD degree and 20 years of experience, but the fact that the employee is quote unquote overqualified for the sponsored job opportunity, it doesn't change the preference category that we ultimately decide on, because it is driven by the employer's minimum job requirements for that job opportunity. So I just want to make sure that everyone in the audience is aware of that. And I suppose it took me some time, once USCIS decided to, or I'm sorry, not USCIS, but the State Department decided to issue two visa bulletins. I take it that everyone who does perm and everyone who does green cards, we had to kind of wrap our mind around that change. But just a quick clarifying point is that USCIS will decide what visa bulletin to be controlled by, the final action date, or the dates for filing. And if they do decide on the final action date, as they've recently done the past couple of months, that's the visa bulletin that you should look at. That will determine eligibility in terms of AOS filing. Okay, and with that noted, let's talk about pre-filing, perm recruitment. So one thing that I want to go over is the differences between timeline versus time period. And, this is pretty basic, but I do think, it's worth kind of exploring. Um, because the Department of Labor in their FAQs, they do make that distinction. The timeline for our purposes in understanding perm is the number of days that has to lapse before the next event occurs. I suppose that's a good way of capturing it. So, I provide some examples here in the slide presentation. As Hugo kind of explained, before one becomes eligible in filing the ETA 9089 after testing the US labor market, a 30-day quiet cooling period has to conclude. Well, when does that 30-day quiet period start? It starts the day after the preceding event occurs. So as Hugo kind of noted, typically, there's two consecutive Sunday newspaper advertisements that need to be posted. Do they necessarily have to be consecutive? Not per se, but obviously it's advantageous for the sponsoring employer to make them consecutive. So I provide that here, January 24th and January 31st. Well, then the 30-day quiet cooling period will start February 1st. That's day one of the timeline. And day two of the timeline is February 2nd. So then, day 30, whatever that day is, that'll be the first eligible day for the ETA 9089 filing. Comparing that to time period, how long does an activity or an event, how long does it have to be? How long must it take place for? So as Hugo kind of noted, the SWA job order has to be posted and go live for 30 days. There might be some distinctions to this rule depending upon the state you're talking about, and that's a time period. As was noted earlier, the notice of filing wall posting has to be posted for 10 business days. So the date that it first goes up on the wall, as you can see from the example provided here, January 18th, that'll be the first day. And the 10-day business day clock starts on that day. And then, whatever the 10th business day is, you can come down on that day. We'll move on to the next slide. And the question is posed here: what level of detail regarding the job offer must be included in the pre-filing advertisements for a PERM recruitment campaign? And this is a huge question. I don't think there is no one size fits all answer to that. And the guidance that Labor Department OFLC has applied is that basically employers need to apprise job applicants of the job opportunity. So it really is on a case by case basis. We don't need to enumerate, we don't need to list every single job duty, every single job requirement or condition of the employment. Basically, as long as the job ad, the pre-filing recruitment, provides a logical nexus between the ad and the position that's going to be described and listed on the PERM application, the ETA Form 9089, then the employer has met its obligation in going through a satisfactory recruitment campaign. So what does that consist of? What's a logical nexus? Some of the things that must be there in the PERM ads is a description of the vacancy, the name of the employer, the geographic area of employment, and the means to contact the employer to apply. So, as you can see evident there, the job requirements, education, experience required for entry into the role. Does it have to be there? Not necessarily. Basically, describing the vacancy, job title, maybe one or two sentences describing what the job is all about, obviously the name of the employer and the geographic intended area of employment, and we'll talk about what that definition means, and how job applicants should contact the employer if they're interested, whether it be applying online, sending a mail-in application over postal mail, or emailing their resume to HR. That information should be there in the job advertisements. So the question is posed: if the employer includes job duties and job requirements in the ads, must they also be listed on the PERM application in 9089 form? Well, the answer to that is definitively yes. If as I mentioned, the job requirements for the open vacant job opportunity, does it have to be in the ads? No. But if the employer, for whatever reason, maybe it's just how they their regular practice, they include that information in the job ads, then the employer is definitely on the hook of including that on the actual electronic 9089 form that's ultimately submitted to to OFLC at the Labor Department. The question is posed: does the job location address need to be included in the advertisements? No, the full address does not need to be included. As was noted in a previous slide, essentially what the employer needs to do is to provide the general geographic area of employment with enough specificity. We don't necessarily need to include the street number, the street address. Basically, the intended city, the intended state that the permanent job opportunity is available, that would need to be included in the job ads. And along with that, if there's any kind of travel requirement or the need for a interested job applicant to reside in a different location other than the main principal place of intended employment, that information will also need to be included as part of the PERM job ads that are posted. I provide some examples here. Let's say that a job is intended for the state of Illinois, there's a branch office for the employer, in the city of Chicago there. So basically, that's where the job location is, and the ads have to specify that the job is for Chicago, Illinois. But as part of the job, maybe the company requires its employees to visit New York, maybe 4 times a year. Well, that travel obligation to visit the company headquarters in another state has to be there, in the PERM ads, even though the main location for the job is still Chicago. And likewise, the second example, if the nature of the job requires the employer to visit multiple locations in different states, then the advertisements have to reasonably apprise interested job applicants that such travel to multiple job sites similarly exists, and the ad should be drafted in that fashion. This is, I suppose this is a little bit more, interesting, and because I do want to, take some time to, to go over the recent, the recent lawsuit that was filed by the Justice Department against Facebook, and I'm going to couch it under this heading here. Does the employer's address need to be included in the advertisements? No, we established that. We don't necessarily need to include the full physical address. The ads might even, suggest that interested U.S. worker job applicants send their resumes to a post office or to an email. Maybe the HR director, he or she is charged to receiving emails from interested job applicants. So the ads can designate that information and instruct job applicants to apply for this open PERM job opportunity in that manner. There currently is litigation going on. Basically the federal government, the Justice Department, has filed a lawsuit against Facebook. And obviously Facebook employs a lot of foreign national workers. A lot of them are being sponsored for PERM labor certification. And essentially, the Justice Department is saying that Facebook has allegedly changed their advertisement and recruitment practice for a PERM labor certification campaign compared to how they would normally recruit for open positions within the company. So as Hugo kind of went over earlier on, there are some required recruitment methods that any kind of U.S. employer sponsoring a perm would have to undergo. The Sunday newspaper ads, a SWA job order, as well as the three additional recruitment methods for professional occupations. And Facebook adhered to that. They stuck to the minimum requirement that they had in sponsoring labor certifications for their foreign national employees. But apparently, from the Justice Department's standpoint, that was not good enough. So this then, obviously begs the question: does adherence, just give me one moment, does adherence to Department of Labor OFLC rules for pre-filing perm recruitment result in discrimination against U.S. workers? Because, basically the Justice Department is saying that, Facebook treated these ads differently. So therefore, U.S. workers in the general population were discriminated against because Facebook tried to massage the recruitment in a way to accept as few US worker resumes as possible. Now, this I suppose is kind of opens the a whole host of different issues. That is, what is the definition of an employer's normal recruitment process? What's the obligation of a perm employer? You have client XYZ. Client XYZ, typically recruits their vacant positions. If they do have a genuine need to fill an open position with a qualified worker, they post that on their employer website, the external website visible to the general public. But for years, if they were recruiting for a perm case, they did not do that. Now, this lawsuit, does it change anything? Now does your company XYZ that you're representing, do they now have to change course and post this perm job opportunity on their website, even though for years and years they haven't done so? Because normally they would do that, if there was a genuine need to hire someone. I present this question, without any kind of solid answers because this lawsuit is still going. I can only provide, what essentially perm, why do employers do perm and what's the entire purpose of perm? So we can start off by saying that this quote unquote normal process, an employer engaging in its normal, recruitment process, advertisement process, what have you, it only applies to the notice of filing obligation, the notice of filing wall posting, and the accompanying in-house media posting or internet posting. And that's important because if you look at the perm regs, the regs are clear that Department of Labor expects that an employer will engage in what it normally does for the in-house media wall posting or the internet posting. But that word normal is not found in the recruitment methods. If someone takes time to read through the perm regs, they'll know that the notice of filing wall posting, the internet, that's not considered recruitment. That's notice to the US workers that company employs. It's not considered pre-filing recruitment. It's just two separate things. So as part of the notice obligation, yes, if such a a job, a vacancy is normally posted internally, then the employer has to kind of go through that normal process. But in terms of recruitment, external recruitment, does it have to go through what it normally does? Well, the regulations say that it does not. There can be a difference. I suppose that kind of leads us then to, a follow-up question here that I have. What is the purpose of PERM labor certification? Now here, you have to kind of take a step back and know that the PERM is not for the benefit of the employer. If anything, the PERM filing is also not for the benefit of the foreign national worker. And, I suppose, I mean, that statement, whether it be controversial or not, it kind of, gets us thinking that, what's the purpose of PERM? The PERM is ultimately for the benefit of Department of Labor, because you see the statute citation that I provide there in the INA. Let me pull it up. Right. So the labor certification obligation belongs to Department of Labor, and that's important. The labor cert obligation does not belong to the employer or the employee. It's for the benefit of Department of Labor, because the INA at section 212A5A states that an employment-based alien is inadmissible unless the Labor Department certifies that there are not sufficient United States workers who are able, willing, qualified, and available. So why does an employer and why does an employee go through the PERM process? It's because the Labor Department has to certify before that foreign national is eligible in applying for U.S. permanent residence that there are not sufficient U.S. workers who are able, willing, qualified, and available. So the certification requirement is on the agency, not the employer and the employee. So because of this statutory provision and Congress, basically saying that Department of Labor has to certify that U.S. workers are not available, Department of Labor, they were like, well, this is impossible for us to do. Let us delegate this to some other entity, to some other audience. And then as a result of that, they created PERM. Because PERM then delegates this obligation to the employer. So even though even though Congress stated that Department of Labor has to certify there are not sufficient U.S. workers, Department of Labor is like, we don't want to be held to do this. We want to delegate this to the U.S. companies who are sponsoring green cards for the foreign national employees, and therefore PERM was created. So, I mean, this is important because, like the purpose of PERM is to conclude that a foreign national is not inadmissible because they'll be held inadmissible to apply for U.S. permanent residence if there is a qualified U.S. worker who meets the PERM job requirements, who is able, willing, qualified, and available. And only upon Department of Labor concluding that there is not a U.S. worker who is able, willing, qualified, and available, can then that foreign national who is inadmissible now be deemed admissible and therefore apply for U.S. permanent residence. It's a tricky thing to kind of grasp and comprehend, but if you look at it from that standpoint, and know that the entire purpose of PERM is not to have a U.S. employer recruit for a qualified U.S. worker, but just to kind of undergo an exercise to make the foreign national from inadmissible to admissible, then I think people will kind of understand that, the recruitment for a PERM campaign, a PERM recruitment campaign, does not have to be normal, does not have to reflect the normal customary recruitment that a PERM employer will typically undergo. It can be different. It was supposed to be different. Department of Labor made it different in creating the PERM program. So I suppose that's the underlying controversy regarding this Facebook lawsuit. I won't belabor the point, but I think it's an interesting exercise for us to kind of know and go back to what the statute says. The statute was intended to basically charge Department of Labor with this obligation that they need to certify that there's not a U.S. worker who can replace the foreign national employee, and only upon then would the foreign national be considered inadmissible to admissible. And Department of Labor, delegated this authority to employers in creating PERM. So PERM is not meant to recruit for U.S. workers. PERM is meant to, basically, make a foreign national eligible to apply for a U.S. permanent residency. Does the offered wage need to be included in the ads? No, the offered wage does not need to be included in the ads. But if a wage rate is included, obviously it cannot be lower than the prevailing wage rate. Hugo kind of went into that a good bit. And the company name change. So, obviously, organizations get acquired, spun off, merge, and how does that impact the perm ads? But I suppose essentially, if it's a successor in interest, situation, the typical documents that we use to prove successor in interest in the I-140 context, similar documentation should be considered to be included in the perm audit file that's prepared simultaneous to to preparing the perm application for filing. Can one ad be used for multiple positions? The answer to that is yes, as long as that ad is in compliance with the ad content rules. The vacancy is specific enough to apprise U.S. workers of the job opportunity being sought. I suppose I provide one example here as provided by Department of Labor OFLC in their FAQs. Maybe one ad can list the exact number of vacancies that are open, 5 attorneys, or just use the word plural, attorneys, or attorneys, comma, multiple openings. That's straight from the Labor Department. Okay, with that, I'm going to hand it off to Nina to talk about online registration, filing the perm, and subsequent steps.
We're going to talk. Thank you, Ugo, and thank you, Min, for all the information. Now we're going to go into the PERM program online registration process. Employers have an option to submit a paper filing of the PERM application. We used to do this a long time ago. It's not often used, so we use the electronic system now. The PERM online system for foreign labor certification offers employers a registration feature. By registering for PERM online, the employer's information is entered at registration, is stored in a profile used to pre-populate key fields of the application. This feature will assist an employer in viewing and or printing previously prepared applications that they have submitted or are incomplete status. Prior to filing an application, the employer must register with PERM online system in order to establish an account. Once the business information is verified, the employer contact is sent an email containing the username and a temporary password. Use a temporary password to log into the PERM online system. A second email will be sent to the employer contact with a unique 4-digit PIN number needed to submit the case to the PERM online system. In addition, employers can create and manage user accounts for its agents, attorneys, or other employees. This allows an employer to create sub-accounts for its colleagues to access the employer's PERM record online. The users will, with sub-accounts, access can enter, edit, reuse, and withdraw PERM applications. However, the user cannot create new user accounts or sub-accounts, nor can the user edit the employer's business information. Benefits of submitting the online ETA Form I-89. Filing online provides system prompts that assist in the completion of the Form 9089. I know I've used them. Sometimes there's small little edits that I have to do. It doesn't let you go to the next question unless it's cleared. Faster application processing time, ability to post, view, and update profile information, track and view status of prepared submitted applications, electronic verification of PERM status, ability to save ETA Form 9089 on a personal computer, ability to use the same case information, including employer data from one application to another. The print and sign page is displayed after the application is submitted, and you have the ability to print submitted copy of the ETA 9089. Employer's responsibility, PERM audit compliance. It's crucial. An employer must prepare and document audit file prior to submission of the PERM. Under the PERM labor certification process, supporting documentation is not submitted with the U.S. Department of Labor, with DOL, with the PERM application. Instead, the employer must retain the required documents and produce them for the DOL in the event of an audit. The requirements for the document retention by employers filing PERM labor certifications are summarized here. We at the CHUG, or at least in our team, we prepare compliance audit files from the beginning of the PERM process and provide the employer with the complete file once the PERM case is filed or have it readily available upon request. The purpose of retaining this documentation is to satisfactorily establish that all DOL requirements were met prior to retaining this documentation. I'm sorry. During the PERM process. It is not enough, therefore, to simply have the advertisements and other documents. It is necessary to be sure the proper procedures were followed in order to satisfy the DOL in the event of an audit. Employer must retain audit file for 5 years. The DOL can submit a PERM labor certificate, the DOL can audit a PERM labor certification either before adjudication of the application or up to 5 years. This means that the employer must keep what is commonly referred to as the audit file or compliance file for 5 years from the date of filing. It is important to understand the required documentation the employer must retain within the compliance file. Okay, this is the list of documentations that should be in the audit file. The prevailing wage determination, the state workforce agency job order, the SWAB order, tear sheets from the required 2 Sunday advertisements, the notice of posting with proof of mailing to the bargaining representative in cases involving a union. Documentation for professional positions must also include evidence of engaging 3 additional forms of recruitment that were discussed earlier. Make sure that dates of posting are clearly reflected. The dates of posting is when it started, possibly in the middle. If it was posted for 2 weeks, perhaps from the beginning, in the midweek, and then the final week. Outcome is an important component of the audit file. The means employers must have record. This means that the employers must have records of the results. This essentially answers the question about who applied and why U.S. applicants were not considered to meet the standards of the ability, willingness, and qualification for the offered position. This documentation includes a summary of the results of recruitment, the resumes of the applicants for the position. There must be documentation of contact with any potentially qualified applicants, including copies of emails, telephone logs, notes from any job interviews with the candidate, and documentation of rejection of applicants. It also includes the business necessity explanation in certain circumstances. In some cases, if the employer's minimum requirements for the offered position exceed the DOL, what the DOL believes is standard or normal, the company must be prepared to back up its need for the stated level of education and or experience. This is what is known as demonstrating business necessity. In these cases, the compliance file must include a business necessity letter from the employer establishing that the particular level of education and or experience is required by the company due to the particular business requirements. This need should be backed up by resumes of other company employees in the specific position to show the consistency in the company's requirements. Other documentation establishing that the employer's stated requirements are within the industry norm should also be kept in the file. You also need to keep the sponsored employee documents. It should hold proof of the sponsored employee that the sponsored employee meets the requirements for the offered position. The file, therefore, must contain documentation of the employee's relevant education with the credential evaluation, if appropriate. In cases where experience is required in order to qualify for the position, the file must also hold proof of the prior experience, typically in the form of detailed experience letters from former employers to outline the nature of the earlier job duties. If licenses or certifications are required for the position, evidence that the sponsored worker held these requirements. What can trigger a DOL PERM audit? Foreign language requirements is common. experience requirement that exceeds the specific vocational preparation, the SVP for the position, unduly restrictive requirements, failure to check the appropriate boxes if it's not caught electronically when you're trying to process the application, and audits can also be just randomly selected. A PERM audit, essentially a request for documentation, since PERM applications are submitted online with no supporting documents, the DOL may issue audit requests asking the sponsored employer to provide evidence they followed the proper recruitment procedures. After the employer responds to the audit request, the DOL will review the new evidence and either approve or deny the PERM. If the PERM case is certified/approved, the employer can move on to the next big step of the process, which is filing an I-140 immigrant petition for alien worker on behalf of the employer petitioner in favor of the employee beneficiary with U.S. Citizenship and Immigration Services. There's an important note that I'd like to point out. A PERM labor certification will remain valid for up to 180 days. After its approval, you must file your I-140 while the certification is still valid, because any I-140 submitted with an expired PERM certification will be rejected by the USCIS.
Okay, great. To conclude our time, I thought, it would be fun, in a strange kind of way to go over some hypos regarding PERM. So, we have these 3 hypos here for you guys to kind of review and consider, and, we can, take any, brave soul who might kind of venture in providing us some answers about, how these situations will kind of play out. But before we go into the hypos, I do want to kind of, make sure that we take any questions. If anything that was discussed previously during the presentation was unclear, feel free to, provide or kind of ask your questions, right now. Any questions from the audience?
I have 2 questions.
Hey,
this is from the the first question is that because of Facebook's case, what do you recommend for the mail resume option for the newspaper and SWA? Because these are 2 places we ask people to mail the resume, though in the website and other places referral we provide email address.
Right. So the Facebook case, let me couch this and preface this saying that, I think everyone will agree that there's no definitive answer, and the lawsuit is still playing out. I think it's important to know that, it's DOJ that's, that has filed a lawsuit claiming discrimination against U.S. workers. It's not Department of Labor, it's not OFLC saying that, Facebook did anything wrong. Granted, it's all part of the federal government. They share information. I'm sure there's a tip-off from DOL to DOJ saying that, you kind of want to look into what Facebook is doing. I'm sure in reality that's what happened. But sticking to the letter of the law for PERM, the PERM regs, my understanding is that the only thing that Facebook was not complying with is a notice of filing. As everyone knows, the notice of filing, the wall posting has to be there for 10 business days, which Facebook did. But they similarly have an in-house media forum and intranet that they make, such opportunities available. So they did not do that. So I think it's without question that they were, not compliant in that area. But in terms of application instructions, sending a paper resume by mail to Facebook, for an interested U.S. worker, is that in violation? I personally think no. I do not think so. There's nothing within the regs. OFLC has not gone into that issue. They don't say, a company like Facebook, a company like XYZ company has to mimic how they typically receive resumes from U.S. workers, and make it parallel to their normal recruitment process. As I kind of went over, there is no such thing as normal recruitment. The entire purpose of PERM is an exercise to make the foreign national from inadmissible to admissible, because that foreign national will only be admissible for employment-based green card purposes if Department of Labor concludes that there are no minimally qualified U.S. workers who are readily available for the job opportunity. Department of Labor has decided that they're going to designate this obligation that they have to employers in the form of PERM. And that's the reason why PERM exists. It's an exercise. It's just a matter of getting to the finish point. And if there's a way for us to strategize to help our clients get to that finish point, as long as within the parameters of the rules, I think there's nothing wrong with that, because PERM is not meant to attract US worker applicants. If anything, I think it would be disingenuous for us to say that, that we want our employer clients to get hundreds and hundreds of US worker resumes for every kind of PERM recruitment campaign. Well, I mean, that's simply not the overall objective. The smaller pool of US workers, the better. I think that's just, the fact of the matter. So if there's a way for us to do that within the guidelines provided by PERM, that's something that we have to explore, and that's something that we have to continue to advise our clients in. So I mean, that's what Facebook did, to my knowledge, and I personally think there's nothing wrong with that. So, for you to advise your clients to continue to have their ads instruct U.S. workers to submit paper resumes, I cannot advise against that, just because of this lawsuit that's kind of ongoing at the DOJ level.
So,
okay.
if I may add, this is Dia. I agree with everything you said. But for me, for some of my clients, I'm actually telling them about the Facebook, investigation that's going on, especially for clients that have batch recruitment, right? So there's going to be several cases which might be impacted by the current advertisement. So I think it might be advisable to just let them know that that this is one of the issues, right? And that they might be, it might be conservative to use an email and give them the option, right? And if they say no, many of them actually will say no because they don't want too many applications flooding their inbox. But I think it might be worthwhile to just let them know that this is an issue that's that's being considered right now.
I think there's value in that. I suppose for the one client that I represent that has a pretty high volume of PERM filings, they give the option to the U.S. worker to apply in both ways. There's an online job posting where you can submit your resume directly through the company's website, but also a paper resume process where they send it directly via postal mail to the HR department at whatever city, whatever state. So is it conservative? Yes. Is it kind of approaching this in kind of a passive manner? Maybe, yes. I suppose it really is a matter of risk tolerance on the part of the corporate client that you're representing, especially for these high volume filers. But I don't know. I feel like, we need to kind of push back. It's, as I said, there really is nothing wrong with how Facebook went about their recruitment campaign. The ads instructing paper resumes, choosing not to post in an online forum, instead of maybe just doing, kind of picking which of the 3 out of the 10, additional recruitment obligations to kind of go through. Department of Labor has vetted all this. They say that this is the process, this is the program. And if an employer 100% complies with that, then in my opinion, they have done nothing wrong.
Okay, good to know. Sorry to occupy your hypo time. I have another question with a real time, real practice issue. So because of the COVID, some companies, especially startups, they have no need to keep a commercial office to keep, and all employees work from home. And I have a case that they just use virtual office, Regus. They have an address, but that's only for mail purpose. And their main office, if it can be called main office, is the CEO's home. And the actual work location is employee's home. So in this situation, for prevailing wage, will we use employee's home address as a work location to apply for prevailing wage? And also for notice of filing, if there's no intranet, does the employer need to email this notice of filing to all employees? And also to list the, the form, how to put there, like main office is a regular virtual office address or the CEO's home address, and the work location. When we put the ad, because we need to specify the geographic area, so we have to use the geographic area of employee's home address.
Right. To my knowledge, I don't think there is a definitive rule to this. I think, with COVID, this is a new area of the law that's just starting to, arise. I suppose the traditional business model of having a main headquarters, especially if someone telecommutes and being able to run the PERM ads and identify the headquarters for prevailing wage purposes, that has always been there. I had my personal thoughts on this, but would anyone else who like, I suppose on the call, if you represented a certain client with this issue, would you want to provide your feedback?
Hey, Min. Hi, this is again Dia. I had researched this a while ago, a couple of years ago. And I think, what I had concluded at that time is that I don't think you can list the employee's home address as the work location, because that's
Okay.
liable to change, right?
Yeah.
They could move to another state altogether, and then, and I've also seen a lot of PERMs, which, in the job description in the, the H14 section where we normally list travel and relocation, they'll put telecommuting as an option, right?
Yeah.
So I think at that time, what I had concluded was that, you identify maybe some sort of an address as the headquarters address. It
Right.
could be the Regis office or maybe the CEO's address, but I'm sure, like, even for tax filings and all, they would have some sort of placeholder address, right, that they use as the company address. So, use that as the place where you're going to do the recruitment. And then, of course, in all the ads, everything, you have to include that telecommuting is an option. And I think that would be in compliance with the farmer memo and all of that, because you are indicating that, the work location is likely to change, and you're just using this, the headquarters address as a placeholder for the recruitment.
Yeah. Yeah, even for situations where, for mailing purposes, the company might just receive everything through a PO box. Like, how does that change? I've never represented a corporate client that, uses a PO box, but, obviously that doesn't really make any sense for recruitment purposes. In such situations, if there's a Regis office, or, maybe just maybe the office of the CEO, the president, I suppose, that might be an alternative, as Dia kind of pointed out. The thing is, there is no definitive answer by OFLC, to Lee's question. I think they've just, chosen to just not answer this issue, even though it has become more common, especially with the pandemic. So it really is just a matter of, what's the next best recourse and what makes sense, according to the farmer memo and, everything, all the guidance that we operate, with. And, those alternative ways of designating it for prevailing wage request determinations and pre-filing recruitment, that's probably the best way to go about it. But, to my knowledge, as of now, I don't think OFLC has directly addressed this issue. Is there another question? I see someone's hands raised.
Hi, good morning. Thank you guys for having this review. My question is, I have a particular case that was filed. The prevailing wage has already been certified, but the thing is, they moved. So the address that they are now using is about 5 miles, arguably commutable distance from the original address that we used for the prevailing wage. What would you suggest how we should approach the rest of the recruitment for this particular case.
Right. So, as you, kind of correctly identify, I mean, if you're talking about, normal commuting distance, 5 miles away, I suppose that, saves the overall, application. I've represented, perm cases where, whether it be at the prevailing wage stage or the pre-filing recruitment, all the way to the 9089 filing, the job location has changed. But as long as it's within reasonable commuting distance, I'm a big proponent on you have to reflect where the job is actually located at that point in time. So the prevailing wage request was filed designating, location X. But now the wage determination has been received and the job has located to location Y. The pre-filing recruitment has to, say location Y, and as long as the employer and the attorney, the law firm are, diligent in documenting this location change and, how it is because of, whatever, I guess at the corporate level, moving the office from, X to Y, and all that is included in the PERM audit file. That is not a standalone reason to deny labor certification, in my opinion.
Thank you.
Okay, I know that we're past our time, so I'll leave these hypos to to you guys to review. I just some really quick thoughts before we conclude. The first hypo is intended to, kind of drive the point that the notice of filing wall posting, it doesn't have to contain everything that the ET 9089 includes. So, I've had cases where as part of the hiring process, the employer has like a job application exam that they have to, administer to interested workers. That was only included in the 9089 form for submission. The notice of filing did not contain that, but that was okay. It's the the OFLC and the PERM regs. They confirm that every requirement, every single element does not have to be included in the notice of filing wall posting. Is it good practice to do so? Yes, of course. It just avoids errors. But can a PERM survive without it mentioning every single thing in terms of the requirements? It can. The second point, the second hypo is intended to capture the issue regarding differences in SVP. Nina did a great job in kind of talking about SVP and how that might be an audit trigger for OFLC, for the PERM audit process. But it's important to know that if your employer uses two sets of job requirements, a primary one and an alternate one, they have to coincide somewhat in terms of SVP, the level and the years of preparation. So here, the example here, it differs. So this PERM will not survive, an audit, and it will be denied. The final one is in terms of the concept of diversion. So if you are curious about diversion, feel free to ask the attorneys that you report to, the team leads, to kind of discuss that point. But an employer has to be careful. Just because that it has multiple positions that are the same available, and attempting to divert a U.S. worker from the position being advertised to another, position that's suddenly available, they have to tread carefully here, in order to avoid risking the PERM to be denied. So that brings us to the conclusion of our, of our little seminar here. So I thank you for everyone's attendance, and everyone have a good rest of the day.